So hello everyone, I guess we could begin. So tonight we're going to be, we will start our discussion of the substantive topics on administrative law. And we'll begin with the introduction to administrative law, focusing on the role of administrative law, the relationship between the separation of powers and administrative law, the scope of administrative law, the principles and values of administrative law, and then the boundaries of administrative law. Before we start discussing these topics through the tutorial questions, would there be any questions that you might have or wish to raise? Questions, comments, before we begin the discussion of the tutorial questions? None? Libby, Elizabeth, did you want to say something? Yes, you could probably, okay, I've unmuted you now. Yes.
I just wanted to say I still don't have the checkbook. Is it going to put me in a huge disadvantage? I mean, not a huge, but a big disadvantage. I probably won't get it for another couple of weeks.
Okay. Yeah, there seem to be a couple of students who have the same problem.
Yeah.
Yes, if I understand it correctly, somebody was able to post some of the chapters in Moodle.
Okay.
Somebody did. It's probably in one of the forums there. Would somebody have more information about that? About the posting of some chapters of the textbook in Moodle? Because I came across some of the messages there that were being exchanged, saying that somebody was posting some of the chapters, the scanned chapters in Moodle. So perhaps you could access that.
Okay, thank you.
So we could probably begin. So let's begin by trying to determine, it's in the general discussion according to Melissa, by trying to determine why do you think is it important to study administrative law? And if you could, can you just post your answers in the chat box? So please post your answers in the chat box in answer to the question, why do you think is it important to study administrative law? You're also free to use the mic.
Oh.
Who would this be?
Can you hear me?
Yeah, I could hear you. Who might that be?
This is Jacob.
Jacob, yes, go ahead, Jacob. Yes.
Look, can you minimize this screen, this meeting screen?
Yes.
So I can.
Hold on. Is that better?
Yeah, that's good.
Okay.
And I've got a laptop in here, but it's not working. So, why is it important to study administrative law? Because it allows you to understand how the government's held accountable, executives held accountable, and also you get to learn about the principle of the rule of law in action and how it works in Australian law. This is from memory. My answer was completely different from this, but I'm still getting my feet with this stuff, so it might take a while. But I'll give you that as a starting point, as probably inadequate as it may be, as an answer.
Thank you, Jacob. Yeah, I'm just going to respond to the point raised by Brad. I won't be able to remember every single answer in the discussion forum. If you could, Brad Corby, if you could just, post your answer again in the chat box, and we could proceed from there. There have been references in the answers in the chat box to government decisions. When we speak of the government decisions, which aspect of the government are we speaking of? Are we speaking as well of the parliament, for example? Would decisions of the parliament be part of administrative law? In other words, can we question or test the legality of decisions of parliament as part of administrative law? No? Yes?
I would say I was under the impression that once the legislation's passed through Parliament, and then it's the job of the executive to administer that policy, then it comes under the ambit of administrative law. But I'm still not too sure about whether actually Parliament is it by administrative law.
Okay, so that's actually correct there. As far as administrative law is concerned, we're only looking at decisions of the executive government. If we wish to question statutes or legislation passed by Parliament, that then goes, we're then entering the field of constitutional law. Okay, and in that context, for example, if you look at it from the viewpoint of the legality or constitutionality of statutes and legislations passed by the Parliament, whether by state parliaments or the Commonwealth Parliament, the benchmark to determine whether or not a legislation or a law or a statute is actually legal would then be typically the Constitution. Whereas, if you base it, if you wish to examine the legality or the propriety of decisions of the executive government, you are not really reliant on constitutional law, but reliant perhaps on the common law system. You rely on statutes passed by Parliament, which might vest certain rights in relation to when certain decisions of the executive can actually be appealed or reviewed by administrative tribunals or by the courts. So that is the context of administrative law. And the other thing is, when we speak of the executive functioning and the executive making decisions, let us be clear at the very outset that we don't limit that as far as the power of the executive government to make decisions, it is not always based on statute. So there are certain inherent powers of the executive government that allows it to make day-to-day decisions without having to rely on a statute that is passed by the Parliament. So there are certain inherent powers of the executive which enables it to make decisions, for example, in relation to immigration, or whether, for example, in relation to a decision to prevent, for example, boat refugees from coming ashore to Australia, or to just quarantine them in certain islands, or to keep them away from the coastal areas of Australia. In that case, there is no need, in all cases, for there to have been a statute that had to be passed by the Parliament that would empower the executive to exercise its powers in certain ways. So there are certain inherent powers on the part of the executive that allows it to make decisions that affect the lives of its citizens. It can also be in relation to the power, for example, to enter into contracts. And in that case, the power of the executive, for example, to enter into contracts, whether the contract may relate to the need to build roads or the need to build bridges, it may not need a power based on a statute passed by the Parliament for the executive to make executive decisions. Now, so going back to the so far we've made a quick distinction between administrative law and constitutional law. So we said that as far as administrative law is concerned, we're looking at the legality or the propriety of decisions made by the executive. Whereas if you look at constitutional law, we're actually looking at the legality or the constitutionality of decisions typically made by the Parliament. And so therefore, if it's a question of testing the excesses or the propriety of decisions made by the executive, that falls within the purview of administrative law. And so, as Chrissy pointed out, as far as constitutional law is concerned, yeah, the question is the legality of the way Parliament makes legislation, and that becomes a constitutional question. Okay, so can somebody take the floor to try to explain to the rest of the class why it is important for us to study administrative law? Now, the one thing that we need to understand is that while the idea of while the field of constitutional law has been there for quite some time, whether it's in the UK or whether it's in Australia, in other words, there have always been for quite some time, for centuries in the UK, for example, questions involving constitutional law. The field of law, which is administrative law, is actually a newer phenomenon. It's something newer. And so the question that becomes relevant for us is, why is it important for us to study administrative law in the first place? Can somebody take the floor?
Yeah, hi Manjo, it's Libby.
Libby, yes.
Hey, so in Australia particularly, administrative law is an important area to study because we in essence don't necessarily have a true separation of powers, because the members of the executive are also generally members of the legislature. And so from that perspective, there's a risk of, what's the word I'm looking for?
Abuse of power?
Corruption. Yes, that's the word. Corruption, thank you, and abuse of power. And so administrative law enables the governed an avenue of recourse when they believe that decisions and actions undertaken by the executive are infringing on their rights or legally protected rights. And that's particularly important in Queensland, where we have a unicameral parliament, because the potential for that excessive use of power is even greater in that context.
Thank you, Libby. That was very good. Now, when we speak of administrative law, and we speak in the context of trying to get certain decisions made by the executive reviewed, what is the newer phenomenon, actually, that administrative law has allowed us for the purpose of testing or examining the legality of executive decisions? What is new about administrative law that allowed us, or that enabled the citizens now to question the legality or question the propriety of certain executive decisions?
Manjo, something that I'd say, maybe, I don't know if it's the answer to the question, but
yes.
Is it more popular now because of access to information and the internet and things go viral on Facebook and all that sort of jazz, and everybody gets like in an uproar about certain issues, like that whole thing about where they were going to deport the refugees or people and take their passports off them or something like that?
Absolutely.
I would never have heard about that because I don't watch the news unless it went viral on Facebook, and then therefore I had an opinion on it. I think a lot of people would do the same. Someone's laughing at me. I know I should listen.
Very good. I mean, that's part of administrative law. Thank you. What else?
The mechanisms, how the administrative law operates, like judicial review and merits, and would the administrative tribunals be a new phenomenon?
Yes.
Or the whole of administrative law is a new sort of branch that's come about more recently. Is that what you're saying?
Yes, that's what I'm saying. So prior to, for example, the establishment of the Administrative Appeals Tribunal under the AAT Act of 1975, there were at least two avenues by which decisions of the executive can be tested, and that was through the courts. And on the one hand, you can question the decisions made by Commonwealth officers on the basis of Section 75 of the Australian Commonwealth Constitution. So especially when there's a writ of mandamus, prohibition, or injunction that is being sought by a party, or when the Commonwealth government is a party to a proceeding. So there is a constitutional basis by which decisions of the Commonwealth officers can be tested on the basis of the Constitution. But the other one is actually the Judiciary Act of 1903, in particular, Section 39B, where on the basis of that legislation passed by the Commonwealth Parliament, it is possible for certain decisions of the executive or of Commonwealth officers to be tested in the Federal Court of Australia, or today be tested in the Federal Circuit Court. But if you would examine the context of that administrative process of reviewing executive decisions, that was based solely on the court system. And the question always is a question of constitutionality or legality of executive decision making.
The judicial review, you know how there's delegated legislation?
Mm-hmm.
Are they delegating sort of administrative tribunal stuff to people? I remember in the textbook it talked about in the Kerr committee, some of their suggestions weren't taken up. And I think having a board of judges that specialised in certain areas, or whatever the subject or whatever the thing they were reviewing or investigating, that wasn't taken up. Is that? I lost my thread, Manjo.
I'm not exactly sure which part I'm supposed to respond to.
I will just ignore it, and I might remember what I was trying to say. Okay.
Yeah. The thing we need to remember is that as far as administrative law is concerned, there's that aspect where the legality of executive decisions can actually be tested and determined through the judicial system, through the notion of judicial review. And that is on the basis of... Yes.
The delegated legislation where they find someone who's an expert in that field to make policy. Have they done that with administrative law, like passed it over to someone, like outsourced it? Maybe past part of the judiciary, some independent body that would look at something. Like, I don't know, but it would be part of administrative law, like the, the Independent Commission into Corruption and stuff. That's part of administrative law, but it's not. Yeah, I think I've answered my own question. I don't think that's sort of anything. They could they?
Let me just clarify the notion of the delegated legislation, because there is a distinct legal meaning to the notion of delegated legislation. What it actually means is that the Commonwealth Parliament, for example, delegates. So remember, in Australia, we have what is known as, I think it was Libby who said it earlier, was it Chrissy, who talked of the idea of the partial separation of powers in Australia. And what it essentially means is that although we have three branches of government, you have the legislature, you have the executive, and the judiciary, there's a partial separation of powers in the sense that the members of the executive ministers, are typically part of Parliament. So in that case, therefore, there is a fusion to a great extent of legislative and executive powers, because the Prime Minister, for example, and his cabinet, because they control to a great extent the legislative agenda, they can determine what the laws should be that will be passed. So there is a partial separation of powers in that sense. And under our Constitution, therefore, it is clear that there is a framework whereby the different powers of government are actually sought to be divided among the executive, the judiciary, and the legislature. And as far as the power to make laws is concerned, that is reserved exclusively to the Commonwealth Parliament. So in other words, as far as the executive government is concerned, the power of the executive government is simply to execute and maintain the laws of the Commonwealth. It cannot pass laws. However, the idea that it is possible for the Commonwealth Parliament to delegate some of the lawmaking powers to the executive has been given judicial recognition and imprimatur. And if you for example, if you look at the Dignan's case, the High Court ruled that it is permissible for the Commonwealth Parliament to delegate some of the lawmaking powers to the executive. And then in that sense, that is what is known as delegated legislation. And the legislation, therefore, that would then be created or passed by the Commonwealth executive or the executive government in the form of bylaws or regulations or policies are considered subordinate legislation. They are subordinate because they are inferior to primary legislation that is passed by the Commonwealth Parliament.
Thank you.
Okay, so in relation, therefore, to administrative law, we just wish to clarify that prior to the development of the field of administrative law, there was the aspect, there was an existence, a mechanism by which decisions of the executive government can actually be questioned and tested, and that was always through the courts. But there are two limitations if you look at it from the viewpoint of judicial review. One of them is that because you use it on the basis, you base an attempt to review an executive decision through the court system, the limitation is that the courts can only look into the legality of executive decisions. So in other words, if there is a question as to whether or not the decision was factually correct on the basis of facts, or whether or not there was a correct use of discretion or a correct application of policies by the executive, that could not be examined from the viewpoint of the court system. So before the idea, for example, of an administrative appeals tribunal, there was a severe constraint in terms of trying to examine or an attempt to have a decision of the executive government reviewed, because you had to go through the court system. So that's one. But the second aspect is, if you know, as you probably know by now, if you test an executive decision through the court system, it can be quite costly and it can be time consuming. Because in that case as well, you would need a legal background for you to be able to question certain executive decisions. But with the rise or with the passage of the Administrative Appeals Tribunal Act of 1975, the Commonwealth Parliament therefore created the AAT, which is a tribunal that does not belong to the judiciary. So it is not a Chapter 3 court, meaning the AAT is not a creation of the Constitution. It is not part of the federal judicial system. It is not part of the judicial system. It is in fact, the AAT is in fact part of the executive government. And it is within yes.
Was that, did you say AAT?
Yes, I did.
Thank you.
So the Administrative Appeals Tribunal is a creation of an act of parliament, and it actually belongs to the executive. Although to a great extent, because it is a tribunal, the judges and the members therein attempt to act judicially. In other words, there are two aspects to that. They need to be independent. They need to make sure that they are not biased. So, and they need to make sure that they must provide people an opportunity to be heard. But still, even if they may attempt to act judicially, they are still not part of the judicial system, and they are not Chapter 3 courts. Now, the other important point there is that the AAT's focus is actually an examination of the propriety or the factual correctness of executive decisions. So now, because of the presence of the AAT, it is now possible for decisions of the executive government to be examined not for its legality, but for the propriety and the factual correctness of its decision. So that's what we call the merits review. You review it on the merits. So that's why it is important to study administrative law, because then you are exposed to the many mechanisms by which decisions of the executive can actually be questioned and can actually be checked. You can actually go to the courts, or you can go through the administrative tribunals. But as pointed out either by Chrissy or Libby earlier, administrative law goes beyond just a question of trying to determine the legality or the correctness of decisions of the executive. Administrative law also encompasses questions about the right to information or access to information. It also involves questions about privacy legislation. It also involves questions about whistleblower legislation that protects people in the event that they would like to report certain abuses or corruption on the part of the executive branches of government. So that would be part of the entire mechanism of administrative law. And obviously, if you speak of administrative law, it's not just a question of going to the court system for the purpose of looking to the legality of executive decisions, nor to the AAT for the purpose of looking at the factual correctness of its decisions. There's also the internal mechanism whereby a decision made by an officer of the executive can actually be appealed within the department. So, for example, a decision made by a visa officer, for example, can be brought up to the Minister for Immigration, or a decision made by a manager of an executive department can be brought to the attention of a government minister. And again, that is part of the system of administrative law. From Jesse, does this relate both to federal and state? Yes. So even as far as the states are concerned, there are mechanisms. For example, in Queensland, we have the Queensland Civil and Administrative Tribunal, which is an administrative tribunal, but at the same time, it's kind of a part of a court system. Now, traditionally, if you look at it from the viewpoint, and we're trying to bring into the idea here the issue of constitutional law, if you look at the federal courts, it is impermissible for federal courts, for example, to undertake non-judicial functions. So in the Boilermakers case, the High Court has ruled that federal judicial powers can only be exercised by Chapter 3 courts, meaning these are courts constituted according to Chapter 3 of the Australian Commonwealth Constitution. But at the same time, in the Boilermakers case, the High Court ruled that it is also impermissible for federal courts to be exercising non-judicial functions unless it is as an incident to the exercise of judicial functions. So for example, for the purpose of making sure that certain decisions are being executed, that would be permissible because that is incidental to the exercise of judicial functions. But the High Court ruled in the Boilermakers case that it is impermissible for non-judicial functions to be exercised by federal courts. Now that is crucial because if you look at the QCAT, meaning the Queensland Civil and Administrative Tribunal, there seems to be a fusion between a civil tribunal, which is in a sense a court, and an administrative tribunal, which is a non-judicial function. Now, the reason why this is allowed is because whereas, and this is important for the purpose of us having a better understanding of the legal system, unlike in the Commonwealth, where there is a clear partial separation of powers, at least, or a separation of powers at the level of the Commonwealth, as far as the states are concerned, the High Court has been unwilling to recognize any separation of powers, which means, therefore, that as far as state courts are concerned, it is permissible for state courts to actually exercise non-judicial functions. So whereas federal courts are not permitted under the Boilermakers case to exercise non-judicial functions, they can only exercise judicial functions in federal courts. In state courts, because the High Court is unwilling to recognize the idea of a separation of powers, it is permissible for state courts to undertake both judicial and non-judicial functions. And thus, you have a court such as the QCAT, where you have a fusion in a state court of both judicial powers and non-judicial powers. Questions so far? Clarifications there? Before we move on to the next tutorial question? Clear? QCAT can be appealed to Magistrate Service for review of correctness in legal decisions. I'm not sure. Brad, I'm not really familiar yet. That's something I have to examine because I'm kind of focusing for now, but it's something I'll have to get back to you. But that's a valid point that you've raised there. Okay. Okay, thank you. Very good. We'll move on to tutorial question number 2. This should be a quick one. How would you distinguish administrative law from other fields of law? So I kind of discussed earlier the distinction between administrative law and constitutional law. Yes, so according to the parties, how would administrative law be distinct, for example, from civil law or criminal law? How do we know, therefore, that we're likely dealing with an administrative law question by just looking at the parties? How would we know?
You'd be dealing with a branch of government, I suppose.
Okay, which particular branch of government?
An executive branch?
Yes. Okay, so you're dealing with the executive branch of government, and who's the other party?
A corporation or an individual?
That's right. So where you have a situation where, you know, you've got the executive government as one of the parties, and the other parties would be the individuals or corporations, chances are you're dealing with an administrative law question. Because if it is just private parties who are litigating with each other, or it's a corporation versus an individual, chances are you might be dealing with a civil law question or a commercial law question, but not an administrative law question. So at the basic, at its core, an administrative law case will always involve the executive government and either a private individual or a corporation. Okay, good. So that was a quick one. Whereas if it's constitutional law, how do we know that, you know, we're not dealing with a constitutional law question in terms of parties as opposed to an admin law case? How do we know? So how would we know that who are typically the parties in a constitutional law case? Can somebody attempt to answer the question there? Yep, so it could be, that typically would be the executive. That would typically be questions about the constitutionality of or legality of laws passed by the parliament. So if it involves the parliament, chances it cannot be an admin law question. It could also be between states. It could also actually be about delegated authority coming from the parliament to the executive. That could also be a constitutional law question. But in that case, you will notice that it is not so much about a decision of the executive government that is being questioned by an individual. It's really more of a question of the constitutionality of the invalidity, for example, of a delegated legislation. Okay. So it can also be about the Commonwealth government versus the state government. That, in fact, is a common constitutional law issue about the powers, the division of powers between the Commonwealth Parliament as opposed to the state parliaments. Thank you, Brad. So let's go on to question number 3. Why is administrative law important to the separation of powers doctrine? So we'll probably begin by explaining what the separation of powers is all about. So why is, so we've got a good answer here from Vanessa. As for the others, can you try to post in the chat box what your answers might be to that question? Why is administrative law important to the separation of powers doctrine?
Hi, Manjo, it's Libby. I'm sorry, I can't type at the moment because
That's
I'm
fine.
in my car driving.
Okay. Are you sure you're allowed to do that?
Yeah, I'm on hands-free, guys.
Okay.
It's all good.
Okay.
I have to pick my daughter up this time at night. But
Okay.
So as far as separation of powers is viewed as desirable in order to uphold the rule of law.
Mm-hmm.
And the rule of law is that everybody should be under the law, inclusive of the government. And so from that perspective, the separation of powers doctrine specifies that it's desirable for each of the three arms of the government, namely the executive, the legislature and the judiciary, to all undertake unique functions, and that none of their functions should cross over into the other in order to avoid issues with corruption and excessive power.
Good, thank you. So that was good. Anyone else would like to add his or her comments? What is the implication of administrative law to the separation of powers doctrine? So it does. So as pointed out by Irina, administrative law does help prevent government agencies from exceeding their power and provides the remedy. But what is the other implication of administrative law because of the separation of powers, where there is a framework where, you know, each branch of government is meant to have its own set of powers that is, and the assumption being that a particular branch of government is meant to be supreme in its sphere. What is the idea behind administrative law? Why is it important?
I don't know if this was already said, but it helps that principle of rule of law function.
Mm-hmm. Okay. So in that sense, what's the implication there if you bring up the notion of rule of law?
Well, it allows no one can be above the law, including the executive.
That's right.
And everyone is equal under it. So
yes.
It puts individuals and corporations as well as the executive on the same sort of playing field.
Yes, that's right. So as pointed out by Melissa here, as well as by Destiny, the separation of power assumes that the executive does not have the freedom to exceed or abuse their powers. So that's one part of it. But the other part is, because of the notion of separation of powers, each of these branches of government are meant to respect the independence and the powers that the other branch of government is exercising. So in other words, it is not, for example, it is not for the legislature to second guess what the executive does, and neither would it be appropriate for the courts to second guess decisions made by the executive. So in other words, for as long as what the executive does is legal because it is according to the law, it is not appropriate, therefore, for the courts, meaning the Chapter 3 courts, to determine whether or not the decision is actually correct. So as far as if, for example, if the executive is given certain discretions or is permitted to use policies, it is not permissible for the courts to intrude into the executive decision-making by second-guessing decisions made by the executive if it does not involve a legal question, because of the idea of respecting a co-equal branch of government. So that's the other aspect of the separation of powers. You don't interfere as much as you could. For as long as it is legal, you cannot interfere. Now, because of the administrative law system, we will see that there is a mechanism within the executive branch of government where decisions of the executive can be tested within the executive branch of government itself. So decisions made by Commonwealth officers can be questioned, for example, in the Administrative Appeals Tribunal. Okay. The judiciary tests these cases only in relation to, as far as the comment of Erin is concerned, the judiciary tests these cases only in relation to the legality of executive decisions, but not as to the factual correctness of decisions. So in other words, once an executive officer makes a decision in relation to a particular dispute or a particular case that it is confronted with, the courts will not re-examine the factual correctness of that decision. Because to do so will actually, in a sense, be violating the separation of powers, which requires a respect for a co-equal branch of government. So the power of the courts is limited to examining the legality of decisions. The only time, for example, as we will later on realize, the only time when the courts will intervene in relation to factual correctness of decisions will be when there's actually an absence of any evidence that would support a decision made by the executive. Because in that case, in the absence of evidence, it can then be said that the decision is contrary to law or involves an error of law. So therefore, it becomes a legal question. So when there is no evidence, you can then say that a decision made in the absence of evidence constitutes an error of law or is contrary to law. Therefore, it becomes a legal question. But otherwise, if there's actually evidence that is available to the executive, and the executive makes a decision on the basis of evidence, even if that evidence seems to be weak, the courts will not interfere with the decision of the executive, as we will later on see, because of the notion of the separation of powers doctrine, which requires a respect for a co-equal branch of the government.
Manjo, can
Yes.
I ask a quick question in regard to legality?
Yes.
So if you had a situation whereby a branch of the executive government made a decision which was based on a workplace policy, for example, which the policy itself was empowered by a piece of legislation. However, while that policy was in line with that specific piece of legislation because it was of a general nature, but yet the policy itself was not in line with anti-discrimination legislation, would that be potentially deemed as an illegality?
So in other words, in that case, the question is not so much the decision itself, but actually the question becomes, the question relates to the legality of the legislation. Would that be it?
The question really is the legality of the policy, given that the policy itself appears to be in direct contradiction to anti-discrimination legislation, even though it is within the realms of the empowering policy that enabled the policy, the empowering legislation which enabled the policy to be drafted.
Yep. So if I understand your question correctly, you were saying that a regulation, for example, that was created by an executive officer was in conflict with a primary legislation or a statute passed by the Commonwealth Parliament. Would that be the context?
The policy is not in conflict with the specific piece. Sorry. The policy is not in conflict with the specific piece of legislation that they are pointing to as empowering the initiation of the policy, but at the same time, it is in conflict with the anti-discrimination legislation.
So in other words, there seem to be two pieces of legislation that have an effect on the regulation passed by the executive officer. So on the one hand, you have a primary legislation which supports the regulation that was passed, but on the other hand, you have another statute such as the anti-discrimination law, with which the regulation passed by the executive officer seems to be in conflict with.
Yes, that's exactly right.
Is this like this question of same-sex marriage, that sort of thing?
Okay. If the point there is not, so we make a distinction between a regulation that is passed as opposed to a decision of the executive. So we make a distinction. So there might be a regulation And on the basis of that regulation, a decision is then made by the executive, as opposed to the question of whether or not the regulation itself is legal. Okay, if the question is the legality of the regulation itself, that becomes a constitutional law question, because the question is, does the subordinate legislation violate a primary legislation? That is a constitutional law question. Now, if the issue becomes a decision has been made on the basis of a regulation that appears to be in conflict with a primary legislation, so therefore there is an executive decision, then potentially that is an administrative law question. In that regard, the court has ruled in the case of Brian Lawlor Automotive versus New South Wales Collector of Customs that it is permissible for an administrative tribunal or an executive officer to incidentally pass upon the legality of a law, but at the same time actually make a determination on the merits of a decision. So in other words, what this means is that it is only the courts, the Chapter 3 courts, that have the power to resolve questions as to the legality or constitutionality of laws or regulations. So when we speak of laws, we speak broadly both of primary legislation passed or statutes passed by the Commonwealth Parliament, but we also speak of it in the context of regulations passed by the executive. So if it's a question of the legality or constitutionality of laws, both primary and subordinate legislation, that is a constitutional law question, and only Chapter 3 courts have the power to resolve those kinds of questions. But if the question relates to or pertains to the lawfulness or legality of a decision made by the executive, which decision was actually based on a subordinate legislation, an examination of the legality or lawfulness of the executive decision falls within the purview of administrative law. So if the question relates to a decision based on a subordinate legislation or delegated legislation, that is an administrative law question. But if the question itself is the legality or constitutionality of a regulation or a subordinate legislation, that is a constitutional law question, which can only be resolved by Chapter 3 courts. Did that make sense?
So Manjo, in that situation, if there was, it did, thank you very much. So in that situation, Manjo, if there was a decision handed down which affected the rights of an individual, given that it appears that the policy itself, while it is in line with the primary legislation that empowers it, but is not in line with anti-discrimination legislation, would there in that case be an avenue for judicial review for that individual who has had their rights affected by that administrative decision?
The answer is yes, because in that case you are questioning now the legality of the executive decision. You're questioning in that sense the legality of the executive decision, because you are saying that the basis of the executive decision was actually unlawful, because the law was unlawful in the first place for violating a primary legislation. So then that becomes it would then be permissible in that case for it to undergo a judicial review on the question of a constitution of legality or lawfulness of the executive decision. Because every decision, because every decision of the executive must always be based on a valid law. So if the basis, if the source of law on which an executive decision is made is invalid, because the law is invalid, then obviously in that case there is an avenue for judicial review, because that pertains to a question of lawfulness or legality of an executive decision.
That's fantastic. Thank you so much for that.
Thank you. Now we move on to the final question, tutorial question number 4. And the question is, if you could, try to identify one key principle or value of administrative law and explain such a principle or value and why it is important. Why is it even necessary for us to know what the key principles are of administrative law? Okay, from B, administrative justice, executive accountability, and good administration. Thank you. Very good. From Brad. I was just thinking that as far as the recording is concerned, the people who will be watching the recording are actually unable to see the chat box because that's a problem with Zoom. Unlike Blackboard Collaborate, where the chat box is visible. And so I realize now that as far as Zoom is concerned, you cannot see the chats going on because it's a separate data altogether. So I'm just posting the answers now on the screen in order to enable those who may be watching a recording to know what's actually being written in the chat box. You can save and post the chat as well. Yeah, that's right. Yep. I should probably do that, Melissa, right? Because I'm kind of used to just posting the recording. I should probably just also include the chats as well. So I'm going to do that starting today. That's good. Okay, can somebody just explain to me this idea about executive accountability and good administration? Why is that important? Why is that important? And what do you mean by good administration here, if you could? Could somebody explain that? I like the answer by Forbes. Forbes was saying it imparts confidence. That's good. So I'm going to write it down here. Good. That's a good point. This is from Vicky. Okay. I'm just. Okay. Yep. And this is from Destiny. Fairness and transparency as well. I'm just gonna zoom in to the point raised by by Vicky. Executive accountability, which aims to ensure the executive can be called upon to explain and justify its decision. I have a question in relation to that specific point because there is such a thing as ministerial responsibility or ministerial accountability to Parliament. So if you notice, because of the partial separation of powers, where the executive ministers and the cabinet actually belong to the Parliament as well, the executive, therefore, in a sense, is accountable to the Parliament, right? And you will notice that during question time, it is typical for the Prime Minister and the members of the cabinet to be questioned during question time by members of the legislature. Unlike in a presidential system, where you will never see, for example, President Barack Obama being questioned in Congress for his decisions, although some of the cabinet secretaries, such as the defense secretary or the secretary of state, may actually be summoned to Congress, but you will never see the head of government in the U.S. Being asked to appear before the Congress to explain his decisions. But if you look at it from the viewpoint of the parliamentary system of government, such as the one we have in Australia, you will notice that it is typical for the Prime Minister to be questioned by his peers. And that is true as well in the UK, where the Prime Minister of the UK can also be questioned by his peers. The same is true as well for state parliaments, where the Premier of Queensland, for example, can be questioned again by members of the legislature. So, in a sense, therefore, we have a system of executive accountability. Accountability on the part of the executive officers being accountable to the legislature. Now, how different is that from the executive accountability here that was it Vanessa stated earlier, that Vicky pointed out? How different is that? So how different is the notion of executive accountability as part of administrative law? How different is that from the notion of ministerial responsibility or the notion of collective responsibility, whereby the executive are answerable actually to the legislature? What do we mean by executive accountability in this context, in the context of administrative law, as stated by Craig and Macmillan? Can somebody try to answer that question there? How different is this?
Is it that they're accountable to the general public rather than to one another? Is that more what it's about?
That's right. So in the end, because of the notion of administrative law, the executive is actually accountable to the public. That's right, as Vicky's pointed out, the executive is answerable to the public. So this is a way whereby the exercise of executive powers, obviously by the executive, can be brought into question by members of the public. And they can do that by, pieces of, by using freedom of information legislation, where they can ask more information from the executive in order to determine, to derive executive accountability. It can also be in the form of anti-corruption legislation or whistleblower legislation, where members of the public can raise allegations of corruption committed by the executive. Again, these all form part of executive accountability. Okay, so that's distinct from the notion of ministerial responsibility or collective responsibility, which relates to the responsibility of the executive to be answerable to the legislature or to their peers in Parliament. Now, how about in terms of good administration? What do we mean by that? What do we mean by good administration?
I think someone said earlier about concerning values. It enables transparency.
Yes, go on.
That's all I've got so far.
Yeah, that's right. So part of it is transparency, impartial governance. Yeah, so good. Yes.
Ethical uprightness. It encourages that sort of characteristic or behaviour.
Yes.
The bureaucracy.
Yes. So there were also answers in relation to fair and equitable decisions, issues of fairness, consistency, transparency. So what it means is we have an idea about what good administration is, right? We have an expectation of how the executive government is meant to operate. We have an idea of what good administration is. Good administration means that we can have trust and faith and confidence in the executive government. We know that its decisions are going to be fair, they will be equitable, we know that they're going to be honest, they're going to be transparent. That's part of good administration. We also know that part of good administration will be efficiency. So we will not tolerate a situation where the executive government will take a year to make a decision on something that we submit or apply for with the executive government. So that's part of good administration. Okay. Good. Okay. Anything else? So from Erin, does this not also transfer down to the minister's portfolio? So I would imagine, if I understand the correction properly, that as far as the minister's portfolio is concerned, we would expect a minister as part of the executive government to actually perform his duties according to the principles of good administration, which means, therefore, that we would expect a minister within his portfolio to make decisions on the basis, make decisions that are fair, that are equitable, and decisions that are transparent as well, decisions that are consistent. Anything else you'd like to add? None? So it's 8:15 in my watch here. Would you like to add anything else?
Manjo.
Yes.
Can you hear me?
Yes, who is this? I can't, sorry. I'm Brad. Hi, Brad. How are you?
Hi. I've made a few comments here in regards to the majority versus a mandate.
Yes.
And you talk about administrative law and good administration. The previous government had a electoral majority of 72-7, so a lot of legislation was pushed through at 1 and 2 o'clock in the morning. And much of those powers are then moved down to the regulatory authority, so they don't actually appear in amendments in the legislation amendments. So, for example, like the value of a penalty point and relevant issues under the Transport Operation TORM Act, those sorts of things. So a good administration is in essence to the benefit of the majority of the constituents, as opposed to minority groups as such. So, for example, they'll make a decision which is not going to please all the people all the time. There's a famous saying, I forget who said that, one of the US presidents, that I won't please all the people all the time. So
Lincoln.
Good.
Lincoln made that.
Right, yeah, Abraham Lincoln.
Okay.
So often you'll see that issue, where they're trying to get, the majority of votes, in regards to, say, for example, the climate change issues that have been a federal problem for the last 5 or 6 years. They're trying to make changes and push their agenda through getting a majority which may not necessarily be supported by the constituents, being the people who vote for them. So the accountability ultimately comes down to election day.
Yeah, I'd like to make at least 2 comments to your statement. The first comment I'd like to make is that, actually I think there will be 3 if I remember them all. The first comment I'd like to make is that as far as the legislature is concerned, or even as far as the executive is concerned, there is no requirement that any of its decisions must always be for the purpose of satisfying the needs or interests of the majority. There is no such thing. In fact, unlike the judiciary, where they are expected to be free from bias, the judiciary has to be free from bias. It cannot be biased. It has to be objective. The point about the executive and the legislature is that by the very nature of their functions, they are meant to be biased. So therefore, as far as being biased is concerned, the executive and the legislature can deliberately favor a minority. They can deliberately disregard the interests of the majority. And when they make a decision in that regard, when they favor, they become partisan. When they act without some sense of fairness, that becomes a political question that courts are unable to touch upon, because that is a political question. That is what is known as a non-justiciable question. So that is something that we need to clarify here. Okay, so the executive and the legislature, by the nature of their functions, are meant to be partisan. They can purposely select the minority in terms of benefits and disregard the interests of the majority, and that cannot be questioned. But in the courts will refrain from reviewing the decisions of both the executive or the legislature in that regard, because that is a non-justiciable question. It is a political question. The other aspect to that is that what we need to remember is that the legislature actually, and also to an extent the executive, are actually representatives of the people. On the basis of representative democracy, we have an understanding that the people have surrendered some of their powers to make decisions for the government to the elective officials. And because the populace have surrendered some of these powers, under the framework of a representative democracy to the legislature and the executive, it is therefore not within the power of the courts to second-guess decisions by the elected officials. So, which is why, as far as political questions are concerned, these become non-justiciable questions, because to the courts, being appointed officials, because courts, remember, judges were not elected, being non-elected officials, meaning being appointed officials, they would rather give it to the legislature and the executive to make the decisions that affect the interests of the people. So if the executive or the legislature decides to make decisions which may appear even oppressive and arbitrary to certain sectors of the community, the courts are unlikely to touch such kind of questions, because on the basis of the separation of powers, they will respect a co-equal branch of government, and especially from the viewpoint of a representative democracy, the courts will leave it to the elected officials to make those kinds of decisions. So in the end, it will be up to the people to elect, to make a decision as to who elected officials will be, especially if they're unhappy with decisions made by the executive or the legislature. But that will only occur in the context of the exercise of the freedom or the right of suffrage. But you're correct when you raise that point, that it can raise, valid questions when we end up asking whether or not the executive or the legislature actually have the interests of the people at heart when they make the decision. That is a valid point.
Thank you, Manjo.
Thank you, Brad. So it's now 8:22 in my watch. Will there be any other questions before we end tonight's session?
Yes, just a quick one about
Yes.
the textbook, because there's so much going on about the textbook. Is it actually using third or the fourth edition?
The lecture notes are based on the third edition, but as far as as well as the lecture videos, they're based on the third edition. But as far as answers to the tutorial questions are concerned, as much as possible, I'm aware of what's being written in the new edition, and where it is relevant, I'll include that information in our tutorial discussions. But the lecture notes and the lecture videos are based on the older edition.
So is it okay to study from the older edition? I bought my textbook just before it ran out. So
it's not a problem. It's not a problem at all. No. If there is a major departure, and there hasn't really been any major departure in terms of administrative law, except for the change in the structure of the AAT, if there is a major departure in terms of administrative law principles, I will flag that to the student cohort. But otherwise, you'll be okay with just using the older edition. You mentioned you would provide a memorandum example. Yes, I would. Right, I forgot. I'll post that tomorrow in Moodle. The exemplars of memoranda, legal memoranda. So I'll post that in Moodle tomorrow. I forgot about it. Yeah, that's right. So legal memo exemplars. Yes. Anything else?
Manjo?
Yes.
I'm just wondering when you think you will post the suggested answers to the weekly questions. Like, what's the turnaround time going to be?
I plan to do it 2 weeks after, or should it be the week after? What do you think? I'm open to suggestions.
I would say the sooner the better, but that's just me.
Okay, that's fine. That's fine. I can do that. So perhaps if we're dealing with the week 1 topics, I'll post them 1 week after the end of that week, just to allow students to post their own answers without being influenced by the suggested answers. Would that be all right?
That would be great. Thanks.
Yeah, because otherwise they'll end up adopting the suggested answers, and I'd like to give students the chance to think about the tutorial questions. So that's kind of a form of active learning instead of just copying and pasting what's the suggested answers. But yeah, I'm going to post them 1 week after. So if we're speaking, for example, of the week 1 topic, I'll post it 7 days after the end of that week. So it will not occur on the Monday at the end of that week. It will be 1 week after. Okay, so again, in order to give students sufficient time to come up with their own independent answers without having to be influenced by a suggested answer. Because for all I know, there really might be very valuable answers that students provide, which I may have failed to actually consider. Jason, what about just after the Zoom session? What's the question, Jason? What's the question there? Is it in relation to the tutorial answers that you'd like me to post them straight away? Was that it, Jason? Yeah, it might be a bit too early. Maybe a week after should be fine. Will that be all right? We'll do it 1 week after. I mean, as I said, I'm open to suggestions. So which one is the yes? Would you rather that I post it straight away or 1 week after? So yes would mean straight away. No means 1 week after.
No, I'd prefer a week after.
Okay, good. So I think a lot of people are saying 1 week after. So we'll go for the 1 week after. Yeah. Because again, as I said, that gives you a chance to engage in active learning, trying to make sense of what the correct answer should be, instead of having to be strongly influenced by the suggested answers. Because I'm more than sure, there'll be a lot of good answers there. Okay, so that's it for tonight. Thanks again for joining tonight's session. And I hope to see you next week. So thanks, everyone, and good night. Bye.
Thanks, Manjo. Good night, all.
Thank you. Thanks, everyone. Bye.
Thank you.
Thank you.